Hello and good afternoon or good morning, depending on where you are tuning in from. My name is John Phelan. I am the Director General of ICMP, and it's a real pleasure to welcome you today to this live event, which we're gathering an audience really from around the world. Just a quick look at our participants panel, and I can see attendees from across India, Europe, South Africa, US, Japan. That's a really fantastic gathering. So a very warm welcome to everybody for today's event. ICMP is the global trade body for the music publishing industry with representation across the industry, including 67 different national associations across 6 continents. And of course, it's an extraordinary industry, licensing more than 100 million musical works. That's almost 90% of the world's entire music, across almost every form of exploitation of music: streaming, live, TV, physical, gaming, and print. So for today's event, we've got a really fantastic audience and speakers gathered for you today for the audience. We will be introducing them very shortly. And as you can see, they're very high level from across a range of public authorities, Indian industry, and of course, then some of our colleagues from across our national trade groups in the US and UK. Before we meet them, we thought we would give a very short tee up to some of the issues that we're seeing within the Indian music sector as ICMP. India is really a very unique music sector indeed, really with some metrics which cannot be compared to any other country. And digital is really leading the way. So what are we seeing in terms of the digital music industry in India? Well, all of the largest players, international players, are present in terms of the audio on demand and video on demand streaming music market. And that take-up within India is leading to quite extraordinary figures in terms of music engagement. As you can see, YouTube, Facebook, and Spotify have quite extraordinary numbers in terms of users worldwide. And that's leaving us today with all internet traffic on the internet. More than 58% of it is video streaming, which just goes to speak to the popularity. However, in India, it is soon set to be the single biggest streaming audience in the world. So that's an extraordinary growth projection. However, there are some challenges. We've seen recently TikTok leaving the market. And when we look at the actual licensing challenges, which we'll be hearing a lot about today, we see that Spotify, for example, launched a number of years ago in the market, not with securing all licenses across our membership. ICMP stepped in to back our company, Water Chapel Music, in that particular issue. And we've also seen the growth of Ghana, JioSaavn, Wink, and many other Indian DSPs. And we're, of course, looking to ensure that those are fully and fairly licensed. In the absence of TikTok, Ghana has recently set up a short video music platform named Hotshots, launched in 2020. And here you can see some of the extraordinary numbers in terms of take-up and music engagement. Here we have some headlines in terms of a market overview in India. India as an economy is set to be the 3rd largest worldwide by 2030. Of course, the demographics are quite extraordinary. 65% of India's population is younger than 35. Digital provision is incredibly widespread, and indeed India has the lowest mobile data retail rates in the world. So the ability for growth of streaming music is all clearly there to be seen. In the broadcast music sector, there is 86% connectivity for public radio broadcasts across the country. And as you can see here, music is incredibly popular. The average weekly consumption of music is 21.5 hours per week. And of course, that's higher than the global norm. We can see that 86% of people in India are using audio streaming services. We have many licensing challenges there we'll be hearing about momentarily. We can also see that 91% of people in India listen to the radio. It is indeed the most popular form of music engagement. However, despite these very positive metrics, we're seeing a lot of challenges. There still is a big problem in terms of infringement of rights across the digital and broadcast music sectors. As you can see, only 3 out of 385 commercial radio stations are fully licensed for music publishing works. And you can see in terms of the industry breakdown of revenue, more than 80% of the music industry revenue is coming from digital. I think that speaks not so much just only to the popularity of digital, but rather to the lack of income coming through the broadcast sector due to the lack of licenses. Again, we will hear about some of the services which are using some issues in order to avoid taking licenses, and that means that many of the DSPs do not currently have licenses in place. And the net result of that is harm to songwriters and composers' rights, and songwriters and composers pay, which is why ICMP exists, is to try and put in place the proper legislative, legal and licensing framework to ensure that that doesn't happen. So what issues will we be hearing about today? We're tackling a number of issues in the sector in India through a number of different fora, both through law reform, trade policy and court issues. These are some of the things that we'll be hearing about today: rights recognition, boosting the broadcast music usage tariffs, safe harbor, enforcement, statutory licensing for the lawyers out there, and extended copyright term from 60 to 70 years, 70 years being the global norm, and issues of copyright awareness. So that's what we'll be hearing about today. With no further ado, let me pass to our speakers to be introduced. And first of all, may I introduce Ms. Jackie Alway, OBE. Jackie, of course, is chair of ICMP and will be leading today's discussion. Over to you, Jackie.
Thank you very much, Johnny. And I just add my own welcome to all of you who've taken the time to join us today for our focus on India, and look at some of the very specific challenges that our industry faces in this jurisdiction. We have a fantastic panel of experts in the legal, political and commercial spheres who are going to enlighten us on the landscape for licensing and achieving fair value for musical works in India. We have Tanvi Misra from the Copyright Law Division at WIPO. We have Pragya Chaturvedi from the Senior IP Advisor to the British High Commission. We have Rakesh Nigam, who's CEO of IPRS. We have Atul Churamani, Managing Director of Turnkey Music and Publishing. And definitely not least, we have Shannon Sorensen, VP of Legal and Business Affairs at the NMPA in the US. So welcome to everybody. Thank you so much for joining us. It's an absolute privilege to have you all join us. And I want to come first to Tanvi from the Copyright Law Division at WIPO. Tanvi, we're very fortunate to have you join us. Perhaps you could introduce yourself to our audience and then help us with some of the legal context as to the intention of Indian law towards musical works, and obviously the need for recognition of the need to license works separately from master recordings. Thank you, Tanvi. Over to you.
Hello and welcome, everyone. I am Tanvi Mishra. I'm in the Copyright Law Division as a legal officer in World Intellectual Property Organization. I'm here to talk about Indian music and the popularity of Indian music, the uniqueness of every music genre that emanates from the rich culture and traditions of India, especially when one thinks of Indian film songs, particularly the Bollywood songs, and how one is immediately able to trace it as a uniquely Indian identifiable genre of music. This uniqueness is what gives Indian music unmatched popularity that, of course, John also referred to with facts and figures, but this is more of an emotional attachment, and the reason why Indian music is so popular, because the songs give a story in the movies, and it takes the narrative of the movie forward. And that is why the popularity is spread widely and deeply also across the world. There are probably very many reasons for such a phenomenal recognition of Indian music, but at the heart of it, there is a recognition of the multiplicity of creative and commercial components in each aspect of music, whether it is the lyrics, the melody, the musical compositions, the sound recording, or the cinematographic works. Music is a blend of the components, but it is so harmoniously put together that each component is not mixed inseparably, but shines through and is complementary to each other. The recognition of this unique blend has been an integral part of the construction and evolution of principles in India, which is behind the robust Indian creative industry. And it builds from identifying the differences with other parts of the world, where music has more of a autonomous, standalone flavor. Therefore, it is important to highlight right at the beginning that there is so much to gain from music globally and within India for the Indian creators, in particular to pay due regard to India's emergence as a destination for global music. India has always systematically evolved the national legal framework in accordance with the international copyright treaties that India is a party to. In reference to music, one can mention the Berne Convention for the protection of literary and artistic works, the WIPO Copyright Treaty, which is a special agreement under the Berne Convention dealing with the protection of copyright works and rights of authors in the digital environment, and the WIPO Performances and Phonograms Treaty. The legal system in India has always been reflective of and attentive to the changes in the modes and mediums of communication brought about by the technological advances, which bring with it new opportunities for the Indian creative industry. Opportunities in ways music is created, distributed, and shared. Technology has not only facilitated new ways and territories for consumption of music, but it has also enabled the creation of new tools for identification of each copyright work, each type of rights, right holder, and the transactional aspects. With the rapid and continuous change in technology that brings about changes in the ways consumption of music, from gramophone records to CDs, mobile phones to streaming, and everything in between, challenges do exist in interpretation and implementation of the chain of rights world over. And there are ongoing discussions and reflections at the World Intellectual Property Organization to reflect on new elements that are growing in importance and to collectively find fair and equitable ways to enable the transformations in the digital music marketplace. Every part in the value chain brings something and every part stands to gain. There are, of course, these challenges which are related more specifically to how one rewards the creators and every stakeholder in the value chain, which is essentially the way the money flows. And this challenge is, again, it's a global challenge. It exists the world over. And India has incorporated provisions on remuneration for transactions, facilitating the value chain, leading the way to show how specific actions can be taken in the more composite creative industries like the Indian industry. Under the international copyright treaties to which India is a party, the minimum standards of protection to copyright works and rights are specified. India recognizes the types of rights for the works mentioned in these treaties, and of course also provides an expansion of relevant types of rights to the other works in which copyright subsists in India, which is to take into account the creative and the incentive-oriented contributions across the relevant spectrum of the value chain. This, of course, could be illustrated in more detail during the course of this discussion. There tends to be sometimes the need to go back in time, but I would somehow say there is no need to go back in time to the music-related debates in a variety of forums when views were reflected on different aspects and different discussions, whether it was related to the structure of transfer of rights facilitated through legal presumptions, which of course over time has given way to a different structure through a robust mechanism of industry-enabled transactions, and now more recently with an added layer of the remuneration mechanism, which of course came at a very opportune time with the digital environment coming to India. Of course, we are conscious of the fact that there are ongoing legal interpretations on how these remuneration mechanisms are implemented. And I'm sure it is something that all stakeholders in the value chain would be thinking about. There is an evolving legal environment in India, and perhaps there are more questions than answers. But what is undeniable is the fact that not only is Indian music a global phenomena, being a locomotive of the Indian creative industry, but India is a destination for global music. There will be a constant reflection on the layers of the different types of rights recognized in music and how to think of ways of rewarding the Indian creators who enable the creation of music. Recognizing that creators worldwide contribute to the richness and diversity of culture, and we all enjoy their stories, their music, their films, and their art. There is a public-private partnership which has been launched by WIPO, which is called WIPO for Creators, which aims to raise awareness and increase knowledge of creators' rights and related management practices. with this brief overview, of course, there is a lot more to reflect on and talk about, and there are nuances to everything that I've said. But I also feel there's a lot more to hear here, and we have a lovely panel of experts from India as well. So I'm eager to hear more, and I pass it on back to Jackie.
Thank you very much, Tanvi. Can I ask you one very quick question in a nutshell?
Yeah.
So the remuneration mechanisms really are indicative of the separate copyright in the musical work, which is reflected in the work that WIPO does with creators. Do you feel that's in essence correct, that statement?
So I mean, it's about the national interpretation of the National Copyright Act of India, and the way the provision has been worded. It is sub judice, it's subject to interpretation in court. It does flow from the exclusive rights in copyright that has been given, as I mentioned, to both the authors of underlying works as well as sound recordings and cinematographic works. So this is, of course, this is all sub judice, and will all be soon clarified.
Okay, thank you very much, Tanvi. Very helpful context. So the issues right now take us to Pragya. Pragya, I'd just like to take a moment to thank you and all the team at the High Commission for your staunch support and hard work for our industry in India. It's very much appreciated. Could you perhaps explain first your role and I suppose the role that Trade Talks can play in helping address industry issues around the world, and then reflect for us on some of the key issues within the scope of your work relating to musical works in India. Thank you, Pragya.
Thank you so much, Jackie. And yeah, I would like to say it's been an absolute pleasure working with you, Sean, and our other industry colleagues. And we've successfully managed to highlight many of these copyright issues to the Indian government. So I really do appreciate all your contributions and all your input to that. So I would first give a brief background into my role here. So I'm based in the New Delhi High Commission as the UK IPO's attaché in India. And I sit here as part of the trade policy team, which is responsible for the government-to-government engagement on different policy issues. And I lead on the IP component of that. The UK IPO has an MOU on IP with the Indian government, and I'm responsible for delivering that MOU. Currently, our team is also working on the ongoing UK-India FTA negotiations, and I'll come to a little bit more detail on that later. But I would first like to start by saying that both the UK and Indian governments recognize the creative industry as a champion sector, and it's a priority for the UK government to seek resolution to the copyright concerns of the UK music industry in India. And the resolution of these concerns is very important, not just for the UK music industry, but for the Indian music industry as well. In terms of trade, a strong UK-India trade relationship is evident, and that is reflected in the ongoing FTA discussions. But there are some challenges faced by the UK and Indian music industry with the copyright regime in India. And as I said before, if these challenges are resolved, it will benefit not just the UK industry, but the domestic Indian industry as well. And I'll come to these issues in a little more detail later. But first, I would like to give an update on the ongoing UK-India FTA negotiations. So last year, to reaffirm our commitment to strengthening our economic relationship, UK and India launched an enhanced trade partnership and also confirmed our intent to negotiate a free trade agreement with a view to doubling the UK-India trade over the next decade. And the FTA negotiations were launched with a visit from the International Trade Secretary in January 2022. And the first round of negotiations started on 17 January, and we saw discussions over a broad range of policy areas of interest to both the UK and the Indian governments, and which included IP. So the discussions were productive. They reflected our shared ambition to secure a comprehensive trade deal to boost the trade between the two economies. And both sides have maintained a shared ambition to conclude negotiations by the end of this year. Then more recently, on 17th March, the second round was concluded, and for this round of negotiations, the focus was on draft treaty text, which was shared and discussed across most chapters that will make up the agreement. The third round is due to be hosted by India in sometime in April 2022, where our focus will be on agreeing the treaty architecture and seeking market access commitments to deliver benefits to UK consumers and businesses. So there is commitments from ambition from both sides to secure a modern and comprehensive trade deal that would remove trade barriers and create new opportunities for businesses in India. And this deal is part of a wider trading relationship with India, which goes beyond the FTA framework, and it is reflected in the 2030 roadmap, which sets the ambition of doubling the trade with India by 2030. So that's it on the FTA front. Coming to the copyright issues that John highlighted earlier, here at the High Commission, we have engaged a lot with industry stakeholders from UK and India, and we have highlighted these concerns to the government of India. Coming to the issue of Section 31D, it has been a long-standing issue for Indian as well as UK music industry. And we believe that it leads to a situation where output prices are regulated without regulation of input prices, and it does result in a lot of harm to the right owners and also involuntary wealth transfer from one industry to another. So a resolution to this issue will be beneficial for both the UK music industry and India's own domestic music industry, and will ensure fair value to right owners for their creative works. Coming to the issue of recognition of underlying rights, it's well established that the rights in a sound recording of musical compositions and the rights in the composition itself, they are separate, and separate permissions are needed for all the rights. But here in India, this issue relates more to contractual practices in the industry, and what would help, in my opinion, is clear legislative guidelines on the need for licenses from music right holders, and also an explanation of relevant remedies, and that will make sure that the rights of music publishers and composers are safeguarded. On the enforcement side of things, we have previously collaborated with industry bodies to gauge the perception of UK businesses about the IP regime in India. And while there is overall satisfaction with the general IP regime, enforcement has been flagged as a major concern for UK businesses. And on that aspect, what I can do is I can highlight what we do in terms of enforcement of IP rights in the UK. So the UK government approaches the challenge of tackling IP infringement, including copyright infringement, in an integrated manner through a combination of enforcement, industry initiatives, educating the public, and providing consumers with the ability to access legitimate digital content. This approach recognizes the value of a broad range of interventions. It ensures legislative powers are complemented by the tools to achieve desired policy outcomes. And our multi-pronged approach, where we work with industry stakeholders, law enforcement, and other government departments and agencies, seeks to address the complex and multifaceted aspects of IP infringement. Coming to the term of copyright protection, the Indian copyright law does already offer a TRIPS Plus term of protection, which benefits right holders in recouping the investments they have made in the creation of their works. However, the proposal for extension of term of copyright from the current term of 60 years to 70 years, it's strongly supported by publishing, film and music industries, both from UK and India. This would give right holders a longer period in which to monetize their works, and it will also be in line with what is the norm in the UK and several other jurisdictions. Also, it would be immensely beneficial to the Indian music industry as well, through reciprocal benefits in the UK. Lastly, on copyright awareness, I feel there's definitely increased awareness about copyright when compared to a few years earlier, but we still have a long way to go. There are some issues that may be resolved to some extent if there's increased awareness about rights of copyright owners and fair and permitted uses of copyrighted content. And I'm happy to share that we have been involved in collaborations with multiple industry partners to promote IP awareness, including copyright awareness. In terms of our vision for the coming months, I would like to say that the majority of our focus in the coming months will be to strengthen our existing bilateral relationship and collaboration with the Government of India through our MOU and bilateral work plan between the two IP offices. Creative industries are definitely a focus area for us, and we are looking forward to partnering with a range of stakeholders on creative industry issues. I would also like to share that with the appointment of the new Controller General of the Indian IP Office, we are looking forward to a productive and strong collaborations between the two IP offices on different rights areas. And to conclude, while as of now I cannot disclose what is being discussed in the FTA negotiations, once we have the FTA mandate, we will have a clear picture of which issues are going to be resolved through the FTA, and then we will continue our engagement on all other issues through our bilateral and market access work. That's it from me. Thank you.
Thank you so much, Pragya. That was very helpful. And we lose Pragya before the end of the event, unfortunately, due to an unavoidable commitment. But if we can't get back to you before then, thank you so much for your participation. Incredibly helpful. And I think we absolutely echo your ask for clarification for the status of the musical work. That would be just hugely helpful for us. Which brings us to somebody at the coalface of the industry in India. So to Mr. Rakesh Nigam from IPRS. Obviously, we see enormous disparity between earnings between the recorded media sector and publishing and musical work sector. You're experiencing all the difficulties of the landscape that we've just been hearing about. Can you tell us about how the state of music licensing is for musical works in India at the moment, and your aspirations for the future? Thank you.
Thanks, Jackie. And for, I may not be a legal expert, but I'm more of a commercial person. So, I would share the experiences of what we have gone through, because I started my beginning in the entertainment industry with Saregama for a short time. And then I was also with Universal Music, looking at the publishing side of the business before I jumped into IPRS. So I have seen, in the last 16 years with IPRS, the ups and downs of rights recognition, of valuation for getting the right value for the music publishers and the authors and composers, to see a lot of turmoil happening in the past few years. And after that, the settlement of all the issues after the amendment of the Copyright Act. In the last 4 years, after the turmoil which happened in IPRS, which was a global known fact, after that, when the authors, composers, and the publishers reached an understanding in IPRS to govern it and to participate in the administration of IPRS, and to see that IPRS grows back into a formidable and a world-recognized organization. I'm just happy to share information that in the last year, in the current year, we would reach around 3,000 million, which in terms of dollar terms is $40 million. Compared to the previous year, we were at $20 million. So we would be growing by close to more than 70% in the current year. In terms of distributions also, we have grown by 25%. So we have done more than 210 crores, which is in 2,100 million rupees. So in IPRS, as John said, majority of the incomes which are flowing through are coming through digital platforms. Even though there are quite a substantial number of Indian platforms who are still refused to obtain a license from IPRS, not just for Indian music, also for international music with regard to publishing rights. When I hear from the legal experts to say that the jurisdictions have said the legal interpretation is that there are no separate rights, I laugh at it in the sense that when 2012 our chairman had got the Indian Parliament to pass a law to say that authors and composers will get an equal share of royalty. It was a far-reaching effect to say that when the legislator passed that authors and composers will get an equal share of royalty whenever music is utilized. So its utilization was a very broad word. It says you will get an equal share, not just in performing rights, but in mechanical rights, in synchronization rights, everywhere, in translation, everything. So that's a far-reaching law. I don't think so it's there in any part of the jurisdiction which I know of any world. But when users try and say that, that there are no separate rights still, that because they only have a right to royalty, I say that's a folly. It can't happen that when Parliament is, as a commercial person, when I think of it, I say when the Parliament is passing a law to say that authors and composers will have an equal share of royalty, it can't be out of zero. That means the intention of the Parliament is that whatever rights are flowing through, the authors and composers for the underlying works will get separately remunerated whenever its sound recording is played or whether its cinematographic film is being shown. So, this debate will continue to go on for some time, but, businesses are not made by interpreting the law, which will be very lopsided. So that is why I say that it's a matter of time that, all of these things will go through and publishing rights will be established separately, independently. Because the way the Indian market has established, unlike globally where the publisher is a separate legal entity and the record label is a separate legal entity, in India, the way the business market has flown, because it's from the film music, the film producer is the first owner of all these rights. So he is the label also, and he is also the publisher, which in turn then he sells all these rights to the music company, which takes over all these rights from the film producers. So it's not that the publishing business or the record label business is not separate. It is there, but it is owned by the single entity. So people confuse it to say that, you're paying to the same person. No, you're not paying to the same person. You're paying for separate rights to the same person. So one person can be owner of both the rights, which I try and explain it to them. But, when people do not want to pay, they try to take excuses that, okay, there is this interpretation of law that there's only a single right to go through. As John said, and as other, in India, there's a potential to grow. Scope is huge in the sense that, we have not even touched probably 20% of the market size. In public performance, we do not license more than 15 to 18,000 venues or events put together. When I look at a country size of UK, when I knew about it 10 years back, they had 300,000 events being licensed, events and shops and malls and establishment license. So in India, the scope is tremendous, but education is quite a challenge, because when people say that, a lot of these shops, event guys, when they, want to do not pay taxes on time or do not pay taxes, do not pay electricity. So say that, what is this music tax, what you're asking for? So, it's a gradual process, but with the advent of international players into the market in terms of retail chains, in terms of events, in terms of other players on the digital side, rights are slowly getting recognized, that because when they come from an international perspective, they know that, these are separate rights and they need to be paid for it. So, that's setting the road to grow forward. The same way in terms of digital rights, we have probably more than 300 million subscribers on music OTT platforms, but most of these platforms are free services. So, when they are free services, the rights owners do not get compensated fairly, even at $1, assuming for $1 for the subscribers, and only 20% get paid. We're talking about close to $700 million in terms of the potential of the music industry to come to, and if 60-70% of that comes back to the music industry, it will take it forward leaps and bounds. And when people talk about price points and that, it's a very difficult market, the same Indian market, we have an Netflix, we have Hotstar, where the price points, the subscriber pays for a Netflix anywhere between $4 to $5 a month. So to say that, when he listens to music on a 21 hours basis, 21 hours in a day and continuously for 365 days, he would be ready to shell out anywhere between half $1 to $1. That itself will take the music industry to greater heights. We definitely require, all collaborative efforts from all the sides to see that, the users start getting to pay. Unless we make the user get in the habit of paying for music, he thinks that everything is free. So that is why, it's a challenge on twofold. That one is the recognition of rights and asking, because music is being consumed more on digital side, the digital subscribers need to be asked to pay for royalties. We can encourage them, the user, whether it's a Ghana, Wink, or a JioSaavn, all of them have still not obtained a license for playing your music. But I tell them that they have active discussions with IPR. They have the intention, but they do not want to pay for the rights. Which I said, no. When you pay for rights, when you pay for the label, when you want to pay for the sound recording, you need to pay an equal share in proportion for the publishing side, because that is what the creativity is, from where the rights flow, and that is how your recording gets created. So it's not that you can pay only for the label but not for the publishing side. So this is a complete education process. And on 31D, as people have said, and John said, and Pragya said, on 31D, the government, we have made representation to the government, ICMP has made, all the publishers have made. The government has been quite sensitive to the issues on 31D, that it should not be a treaty violation, whether internet can come under a broadcast definition. So because broadcasting is a very separate creature, and it has got its own interpretations of law, its own regulations, that people do not want to get governed by a broadcast, because the broadcast comes with a lot of ifs and buts and a lot of regulations and controls by the government in terms of that. So 31D, the government is quite sensitive to it. The one thing which I would feel that government should actually, or everyone should push for it, is that in India, there are too many restrictions on the way how you can do business in terms of tariffs. By anyone can go and challenge a society's tariff or a publisher's tariff or a label's tariff in front of the copyright board or in front of the tariffs, in terms of whether it's public performance, whether you go for compulsory license for radio, you got statutory licenses, you've got 31C for the regards virtual recordings. But I fail to see any deterrent in the law in terms of when a user does not take a license and does not remunerate the right owner. So there has to be a deterrent. There has to be some kind of a statutory fear, statutory damages, that when you do not take a license or do not pay royalties on time to the right owners, there should be a fear of law that you will be penalized for it, which I do not see. There are too many checks on the rights of the owners, but there are no checks and balances on the rights of the users. So this is a very strong, this is an area where I would urge everyone to present its case to the. We will also do that to the government, that when you are regulating the rights of the owners of the right, the same penalties or discouragement has to be there with regards to the users' rights. Yeah, Jackie, that's it.
Thank you so much, Rakesh. That was incredibly eloquent and passionate, and much appreciated. So, and certainly as a company that is a standalone music publisher in India ourselves, I absolutely endorse your call for acknowledgement of that separate right, which exists and needs to be remunerated correctly. So thank you so much for that. Which brings us to Atul Chirumani, who is one of the leading independent music publishers in India and absolutely experiencing everything that we're talking about firsthand. Atul, do you want to tell us about the challenges and successes and difficulties you face in the market, and how you see it unfolding in future? You're on mute, Atul, sorry.
Sorry. No, am I? Can you hear me now?
Yeah, absolutely. Off you go.
All right. So thank you, Jackie, and thank you to the ICMP for having me on this panel. Jackie, I'm the dinosaur in the room. I joined the music industry in 1987. So indulge me. I'm going to give everyone a little bit of a historical perspective of India and why Rakesh, Tanvi, Pragya have highlighted some issues that seem to be a little peculiar. In a nutshell, our music industry started in 1901 when the Gramophone Company of India was set up by what became EMI later in the day. It was a record label. It had an uninterrupted monopoly for 31 years, and then an Indian independent called the Indian Record Manufacturing Company came up and also did what the Gramophone Company of India was doing: recording studios, manufacturing plants, distribution of physical product. They were a record label. 1969, Polydor arrived, record label, manufactured, distributed physical product, recorded songs in their studios. In the mid 1980s, we had a bunch of independent Indian companies come up. You've heard the names T-Series, Tips, Venus. All of them played Follow the Leader, all of them record companies, all of them manufacturing cassettes by that time, owning the underlying works, as Rakesh mentioned. We are not a publishing country. We are a record label country. It took till 1998 or 1999, when a not so young Frenchman called Achille Fowler showed up with a BMG license to collect mechanical royalties, that everyone said, what the hell is he talking about? So he went to the record labels that were licensees for international music and said, you've got to pay us for mechanicals. And everyone said, show us in the Copyright Act where mechanicals are mentioned. And strangely enough, there wasn't any particular mention of mechanicals. There was a section called 521J, which everyone referred to for cover version recordings. And they said, this is on the second recording. This is not on the first recording. So Achille stood up and challenged that. It's still unclear as to whether that was meant to be for covers or it was meant to be for the first recordings. But that was the genesis of this whole business of a record label owning the underlying works in the absence of a music publisher. The first music publisher, I think Jackie, Universal set up first in India as an independent publisher. It came over 100 years after the record labels were in the country. So the natural thinking for any user is to go to the record label for the recording and assume that he's getting the underlying works. And we've had situations where I've worked for record labels that were licensing international product. We used to license the recordings without reference to the publishing. So there was a natural assumption on the part of everyone that once you had the recording license, you automatically got the underlying works. Now that is exactly what was challenged and amended in 2012, as Rakesh said. And maybe our English wasn't so great when we said equal share instead of equitable share, but that's fine, you know. So the great thing is the composers, authors are now getting 50%, but 50% of what? That's exactly what Rakesh was talking about, utilization. It doesn't really specify. So there is a historic issue, and as Rakesh also mentioned, that it can only be overcome through awareness. You've got to have awareness of the underlying rights. And that's where, you know, someone like Turnkey becomes important, because we sub-publish Cobalt music in India. And when we had the IPAB and we had the Delhi High Court submissions, Turnkey was an important company when we submitted that we didn't own a recording, because the natural assumption is that if a user is paying a record label that owns the underlying works, it's their problem. They need to pay the composers and authors. They don't need to, you know, they don't need to issue a separate license. However, Turnkey is a standalone music publisher. There is no recording with it. The recordings are with Universal and Sony and Warner, etc., etc. So now we're going to get judgments, I think, in the courts, in tribunals, etc., which recognize that there is a need to pay separately for the underlying works. There's a lot of legal work that's gone on. Tanvi's spoken about it, Pragya spoken about it, and it will evolve. But that's the genesis of the challenge that people, you know, have the reason that people have put forth the challenge of having to pay separately for underlying works. So, you know, it's understandable, but it needs correction. India is a gigantic market, as Rakesh said, and, you know, I'm a huge supporter of IPRS. I think consolidation is really the path to progress. I was mentioning to John the other day. So John, I checked some numbers, and I told you that there were about 5 million establishments in India. I was completely wrong. There are 23 million establishments in India in the organized and unorganized sector. IPRS licenses about 50,000 of them. So if you're just talking growth, that's straight potential to grow. As has been mentioned before, 385 radio stations, FM radio stations, they don't pay. 420 All India radio stations. And by the way, John, they don't go to 86%, they go to 99.19% of the population. That's 92% of total coverage of the country. We have, 36 television the national broadcasters called Doordarshan. They have some 36 television stations. At last count, we had 896 cable and satellite television channels. Very few of them actually pay IPRS yet. The growth story is phenomenal, but we can only grow when we come together. And my grouse with the industry always has been that the collective story is weak because we don't come together collectively. Even today, some of the big copyright owners for Bollywood music and other non-film music are not members of IPRS. Now it becomes very difficult. You're talking about telcos. Telcos have, there's Wink, there's JioSaavn that are not taking licenses from IPRS. Just imagine, I mean, if they had to talk to people individually, you can get almost all the Indian content licensed through IPRS. You can't do it with international. Cobalt and the few other publishers that we represent are sitting inside IPRS, so you can have that conversation. And when I speak to the telcos, they say, listen, we can go to IPRS, we can get a consolidated license, but then after that, we can't have individual conversations. So that is the challenge that those guys face. We've got to look at it from both sides. And I think the easy solution to it is for everyone to get into the collecting society so that there is one license going out to the user, and it's a consolidated license. They're getting everything through that one license. In the absence of that, there's definitely going to be challenges. Rakesh mentioned they don't want to pay. Obviously, they don't want to pay. It's a business, right? But if we are consolidated, if we are giving them that one consolidated license and the window through which to operate, it'll become easier to have those conversations. That's my take on it. On 31D, I think it's the lawyers that need to get into that conversation. But India is a very low-priced market. Rakesh mentioned the number of users. I was just reading the last report that the IMI put out. I think they're talking about growing to 5 million paid users, 5 million, 50 million paid users. I can't remember what it was, but it's a very small number. So the main money is going to come through advertising. Advertising rates are low. YouTube, we know, pays the least out of all the streaming services globally. In India, those rates are even less. I think they're 1/3 of what they pay globally. So we've got to be cognizant of the fact that India is a cheap market. And if you're a cheap market and you go for statutory licensing, then you've got to have a very, very good percentage of the revenue to make the statutory license fair for the copyright owners, who are the ones who are spending the money creating the music. So that's my little take on it, Jackie. I hope that helped.
No, thank you, Atul. I mean, I'm old enough to have been at BMG with Ashil all those years ago, and I'm very pleased to say that we did actually take proceedings and establish that there was a separate mechanical right for musical works. We were very proud of that achievement. So that's good news. And also, if any of the services are listening and need licenses for international repertoire, we can provide very clear signposting for you. You know where we live. So thank you, Atul. That was very helpful, practical roundup. So now we come to Shannon. Thank you so much for joining us to give us the US perspective. Perhaps you would just like to tell us what the sort of key issues are for you in the Indian market from your point of view.
Absolutely, thank you. And I'll make it quick because I know we're running short on time. So I have a couple notes, but I think rights recognition has been very heavily discussed today, which justly so. But I'll just add on rights recognition that from the US side, what we're looking at is the viability of international investment in the region and the viability of sub-publishing. And for that to be viable for US music publishers, the rights absolutely have to be recognized as separate and distinct from the label rights. And so I appreciate all the comments that have been made today, and I echo those. I do want to touch on Section 31D. This is the sort of area in India that NMPA has been the most focused on. And I can give a little bit of background for the non-lawyers on the call. Hopefully I can turn it into plain English. But so what a compulsory license is, for those who don't know, is where in the law it says you have to license, you don't have a say, and here's the mechanism for setting the royalties. But essentially it means if you're a creator and you have a song, you are required to license it whether you want to or not. So the major problem with this is it removes bargaining capability when it comes to licensing negotiations. We've seen that a lot in the US, where we have a statutory license for mechanicals. The way that has played out is that our revenue that publishers receive from digital streaming services is about 1/3 of what the record labels receive, and that's directly due to the compulsory license. So I think it's really important to understand the economic implications and the commercial implications of compulsory licensing, which is that they uniformly depress royalty rates and reduce the value of copyrights. So that's sort of why they're bad. And then what's happening in India is there's been a statutory license for traditional broadcasting. And then there are some, both within the government and streaming services, who are pushing for that traditional broadcasting statutory license to be expanded to digital broadcasting. Particularly as digital broadcasting becomes an even bigger market, it's really important to preserve the economic potential there, and taking digital licensing out of the free market and putting it under the compulsory would have serious implications for music publishers in the Indian market. And that's all compounded by this lack of rights recognition. But as we're recognizing those rights, it's important to preserve these revenue streams and not sort of handicap ourselves by letting that get put under this umbrella of statutory licensing. So what we have been working on from NMPA's side, and I know ICMP has been doing a ton of work on this, and we really appreciate that. On NMPA's side, we've been working closely with USTR, the trade body here, to push for resolution of this issue. We've also been working closely with the IP and trade staff in the US Embassy in India, and they're very understanding and sympathetic to our concerns around 31D and have been extremely helpful. So here's what we've seen. One is USTR has, for the last number of years, had India on its priority watch list when it comes to global IP protection and enforcement. And one of the reasons for that is because of this attempt to expand the scope of statutory licensing to digital broadcasting. And then in November, the US Trade Representative traveled to India and had a meeting, a US-India trade policy forum between the two countries. And we're very grateful to the embassy staff there who raised the issue of 31D and made sure that that was on the agenda. And we saw some very encouraging outcomes and a commitment from both countries to honor their WIPO obligations, but also some indications from the Ministry of Culture that they agree that the statutory license shouldn't be expanded. So that was extremely encouraging. What we would like to see now is a formal rescission of the 2016 memo from the, I think it was DIPP in India, that contradicts the law and contradicts the court decisions saying that digital transmissions are not currently part of the statutory license. And I think the existence of that memo creates a lot of confusion. So that's where our focus is now, is having that formally revoked. And I'm happy to touch on anything else, but I know we're short on time, so I'll keep my focus on 31D.
Thank you, Shannon. That's extremely helpful. We've got only a few minutes left. We've got one question in the chat box, which is an interesting question, so we'll take that before we wrap. And the question is from Kunal Bindra. Would a unified license in India, like PRS's the music license, help in overcoming the confusion surrounding the separation of rights? And of course, that's a joint license for public performance in the UK. I'm going to address that to Rakesh. I think you're probably best placed to answer that.
Yeah, that's quite an interesting question, and I support that. We should make life easy for the users. You need not multiple people need not approach a user with regards, especially for public performance, when because the hotel, restaurant, malls, and they are not in the business of entertainment. It's a support function for them, or at best they are creating a right ambience by utilizing music. So, I believe that in India, because now with performers also being granted rights, there is a separate society for performers also. So, there has to be a unified window, especially with regards public performance, so that, the sound recording, the performers rights and the publishing rights can be collectively granted, so that users cannot be put at a disadvantage. At the same time, if it's going to be done, it has to be done with the mandate of the government that this will be there, and sharing ratios need to be fixed, because otherwise there would be too much of heartburns in terms of who would get what share, because what we have seen in Malaysia, what has happened, which has led to a breakdown of the joint licensing between the recording side and the publishing side. So in this case, we would love to have this, but there has to be some kind of an agreed mechanism that all right holders would participate in it, and there has to be even laid down sharing ratios, so that there are no heartburns vis-a-vis sharing of the royalties.
Thank you. That was indeed a very interesting question. So we're up to time, but I want to, Johnny, unless do you want to say a few words before we finish, and then I'll wrap?
No, I'm just impressed with the punctuality. Well done, everyone. So I think from our side, we're okay. Over to you, Jackie.
Okay, well, this has been a really enlightening panel. I think the audience hopefully can hear the layers of challenges that we face in the market to grow music publishing, to the potential that is clearly there, but is suffering a degree of confusion based on custom practice, and some difficult case law and some ongoing proceedings. But we're here, we're all investing, we're all engaged, we're all passionate. You could hear the passion from our speakers today. I'm grateful to everybody for your contributions. You've been an amazing panel. Thanks very much to the audience for joining. You stuck with us through to the end, so very grateful for that. And hopefully see you all soon at the next ICMP digital event.
Thanks very much, Jackie, and thanks to all our speakers. If you want to follow up on this, it will be uploaded to our social media channels, so keep an eye on those as well too. And we look forward to seeing you soon. Thank you very much, everyone.
Thank you.
Thank you.
Thank you.
Thank you.
Thanks, Jackie. Thanks, Aaron.
Thank you.